Good morning, or good afternoon, or good evening, depending on where you are in the world. Uh, Welcome to the webinar on water tenure and water rights. I'm Christopher Neal, the Director of Research of the Daugherty Water for Food Global Institute, and we are happy to be hosting this webinar today. We have three distinguished speakers today, which our moderator, Dr. Paulo Tarso, will be introducing. First, I will introduce Paulo, right? Dr. Pires is a professor at the Federal University of Paraná in Brazil, in the state of Paraná in Brazil. He has a degree in law and then went on to do his graduate studies in forestry and got a doctorate in forestry, and has worked in Brazil in teaching and research in policy, environmental policy, water law, and other aspects. And so Paulo has been spending over a year now with us here at the Water for Food Institute, and being involved with several activities that we have with FAO as partners and other things. So I'll pass it on to Paulo, and he'll be introducing the speakers and moderating the session today. Paulo?
Okay. Thank you, Christopher. Hello, and thank you for this kind introduction. And I am very excited to work with you for the next 90 minutes. And now it's my pleasure to introduce our webinar speakers. And first of all, I want to introduce, and I have the pleasure to welcome Dr. Stephen Hodgson. He is speaking on behalf of FAO, Food and Agriculture Organization, and Know What Project. And let me read the CV of this kind friend that opened a space in his hard agenda to speak with us today. Stephen Hodgson is a prominent environmental lawyer in Brussels, Belgium, working in projects all around the world. He is legal consultant of Food and Agriculture Organization, FAO, and author of many books and articles such as Exploring the Concept of Water Tenure, Modern Water Rights, Theory and Practice, and Land Water, the Rights Divergency. Today, he will be sharing with us his expert opinion about water tenure in a changing world. Welcome, and now you have our attention and the microphone. Please, Stephen.
Good afternoon, good morning, good evening, everybody. So I'm going to talk to you today about water tenure and FAO's work on water tenure. So if I can change the slide. Okay, so the background to this work on water tenure is the voluntary guidelines on the governance of land, forests and fisheries, which was adopted in 2012 by the Committee on Food Security of FAO. The purpose of the VGDT, which I'm sure many of you are familiar with, is to set out principles and internationally recognized standards in order to provide a framework for actors to develop their own strategies, policy, legislation, and programs. So this voluntary guidelines approach has been pioneered by FAO. It's very successful. It's a soft law instrument that has real weight. And typically, as with the voluntary guidelines, the basic document is followed up with technical guidelines on specific issues, as you've got an example on the left. So the original intention was to include water in the voluntary guidelines, and some preliminary analytical and technical work was undertaken, including the preparation of draft technical guidelines. Now, in the end, water tenure, was omitted for a range of reasons. And one of those reasons is simply because many people don't know what water tenure is, and fair enough. There is a little bit of literature that refers to water tenure, but it's not a term in common usage. So when you say water tenure, common reaction is, what's that? So even though water tenure wasn't included in the voluntary guidelines, FAO has continued to explore the concept on the basis in particular of some case studies undertaken in India South Africa, and Spain, and the ongoing work to be presented below. A first question, though, how do I move on, is what is tenure? What is water tenure? So we're using this working definition based on the FAO land tenure definition, which is the relationship, whether legally or customarily defined, between people as individuals or groups with respect to water resources. Now, 3 key points to note here. First of all, tenure is concerned with relationships created on the basis of formal law, as well as those that are not, so customary law, for example. So it's legal pluralism, in other words, we're looking at all kinds of relationship. Second, the notion of relationship is not just my individual relationship with water, it's my relationship with you as regards water. And in fact, it's my relationship with everybody else in society as regards water. So in other words, we recognize that tenure is a social concept as well as a legal construct. And finally, we're focusing on water resources. It's not just water. This is separate to the human right to water. We'll come back to that later. This is a relationship with particular water resources, water in the natural environment, water in nature. In contrast to land tenure, though, what's interesting is that these relationships are physical as well as social, and they can take place over great distances. So the diagram on the left is supposed to be land plots. If I'm the owner of land plot A, my relationship with everybody else, with society, is at a social level, except with regard to the neighboring land plots B, C, and D. There I may have some tenure issues in terms of support, in terms of encroachment. The person in land plot X, I've got no real formal land tenure relationship with, maybe a nuisance relationship if he plays loud music, but I don't actually have a physical relationship with him. It's a social relationship that recognizes among the society concerned that I'm the owner or the user of land plot A. But with water tenure, it's quite different. So this diagram here is supposed to be an area of customary land and customary tenure. So land tenure, forest tenure, fisheries, water tenure are regulated on the basis of customary law. And that kind of system can work perfectly well over many hundreds of years. However, in my diagram, a river flows through. If upstream somebody builds a reservoir and then an irrigation system and then a factory, their water tenure relationships are going to impact my water tenure relationships at the customary level. So we have social relationships, which may or not recognize each other, is customary law recognized by formal law. And we also have a physical relationship in terms of the actual resource itself, which is a little bit different to land tenure and kind of interesting. As I said, we did some preliminary research in South Africa, India, and Spain. And one of the things we found out was that, boy, were we wrong, were we naive. One of the main things we found was an enormous variety of water tenure relationships, which are set out in the 2 columns here, those that derive from formal law and those that don't derive from formal law. And if you like, the scary thing is that it's very clear that these lists are not complete. We're discovering new types of water tenure relationship as we do more research. Just to quickly take you through them, in terms of formal water tenure, formal water rights, these are commonly established on the basis of land tenure rights. So on the left-hand side, you've got for surface waters, people adjacent to streams and rivers have rights to use those resources on the basis of riparian doctrine, on the basis of public law or private law in the civil law tradition. I won't go into the detail, there's not enough time, but you get the picture. Of course, there's a prior appropriation approach of the Western United States, but that's a little bit different. But generally speaking, formal water rights tend to be based on land tenure rights. Same for groundwater, whether on the basis of the doctrine of capture or the doctrine of private water in the civil law tradition. Basically, you only have rights to water once you abstract it. So this is fine in the 2 wells in my diagram, but if somebody else comes along and digs a deep well, the zone of depression, the cone of depression will take all the water away and the other rights will be destroyed. Now, when these kind of simple legal rules were developed in the 19th century, they worked perfectly fine. There wasn't so much pressure on water resources, but now they're no longer fit for purpose. It's very clear that the rules for surface water and groundwater based on land tenure rights are not workable. So many countries have transitioned to what we call modern, long-term permit-based formal water rights, sometimes regulatory licenses. So under this kind of system, if you want to make an investment, you apply for a permit for 25 years for a major investment, for 12, 10 years for a lesser investment, that gives you a legal right to abstract and use water. Of course, the permit is subject to conditions, and the water law sets out the basis for the allocation, suspension, and cancellation of those water rights. Some people don't like the term modern. I only use the term modern because they're different to the traditional land-based water rights. In some countries, you get annual one-year licenses. I don't see much point in that. You're not going to get much security of tenure from a document that only lasts for 1 year, that confers a one-year right. Moving on, other types of water tenure arrangement. First of all, this diagram, I hope it's clear. It's supposed to be a river running through with a reservoir and then canals, left bank and right bank, conveying water to irrigation schemes where there are water user organizations. So the first type of tenure arrangement, agency control, quite common where a law gives a regional development agency or an irrigation agency broad powers to develop and use water. And on that basis, the agency can go ahead and build new infrastructure. The problem with that kind of approach is it's not usually very well linked to other types of water tenure relationship. And another problem that can arise in countries where there is a system of formal water rights, permit-based water rights, irrigation agencies sometimes say, well, we're the state owns all the water, so we can basically do what we like. And that's not really uncommon. The next type of tenure relationship is the water supply contract, under which in this example, the agency supplies water to the water use organizations at point, the red cross. The length of the contract is the really key issue here. If you've got an annual contract, there's not much security of tenure for the water use organizations. A longer term contract will give more security, providing everyone complies with the rules. Then the next type of arrangement in this particular diagram is what we've called common hold tenure, where farmers' rights to water are held in common with other members of the water use organization, the irrigation district, the water use association. And for that kind of right to work effectively, you need a properly functioning water use organization with good governance. And in this particular diagram, you need a clear contract between the water use organization and the supplier. And of course, the supplier has to have his or her or its own rights to water in the first place. So pretty complex, a little bit like some land tenure relationships. Moving on quickly, another type of tenure arrangement is the investment contract. Many developing countries in particular are trying to lure foreign investors, particularly for agribusiness, giving them vast concessions over land. The land typically needs the water. The concession agreement often gives rights to water, even if the land concession is given by a land ministry or an agriculture ministry without consultation with the water resources ministry. That's dangerous. What's even more dangerous is these concession agreements are regulated by international investment law very often. They're usually highly secret, they're totally confidential. Civil society has no idea what the agreements say. And of course, if there is a breach of contract or an alleged breach of contract, the dispute is resolved not by the national courts, but by international arbitration. And the arbitration award is enforceable under international law against the host government. So if it goes wrong, it goes really wrong. This is not just limited to agriculture. On the right-hand side is the Xayaburi Dam on the Mekong River in Laos. It's subject to the same kind of investment contract, concession agreement. Only the Ministry of Energy and Mines knows what that agreement says. Nobody else does. Unfortunately, this is very common, and obviously it doesn't fit in very well with other types of water tenure arrangement. Moving on quickly, a work of art on the left. Most water laws give people the right to use small-scale amounts of water for cattle watering, for their own personal needs, for their household gardens. That's very common. For small-scale commercial uses, it's very often not possible to give everybody a permit. It's just too expensive. So many countries have a system for small-scale commercial uses to take place without a license or permit, sometimes on the basis of a declaration. This is a little garden in Laos. Just as we can have relationships relating to the removal of water from rivers, we can also have relationships that require the water to remain in the rivers for the purpose of minimum flows, for reserves, for environment, or in order to meet basic needs. So that's another kind of formal tenure arrangement. Moving on to tenure arrangements that are not created on the basis of customary law, of formal law, but which may be recognized by formal law. There's a nuance there. We have customary water tenure on the left, as we've already discussed. Religious water tenure. This is a tank in Madurai in India. That could be very important also for sacred groves, for sacred forests, just as important in many parts of the world as whatever formal law might say. And this is a key issue because the reality is that even if countries have adopted formal laws, they're not always very well implemented, and very often outside the urban areas, customary law, local law is what really matters. Informal water tenure. Sometimes this is just simply illegal. People stealing water, big businesses, small businesses, everyone knows it's wrong. It happens all around the world. Sometimes it's a bit of a gray area though. This is a irrigation canal in Georgia. I'm in the Republic of Georgia, not the state. I'm not sure whether this is legal or not. It's tolerated by the irrigation agency. It's like a kind of squatter's rights, but I'm not convinced that's actually legal. It's certainly informal. Then unrecognized tenure. Water laws are concerned with the abstraction and impoundment of water. But what about those people who rely on water for their livelihoods, like this fisherman in Burkina Faso? If they empty the canal, his livelihood is gone. And very often decisions to empty canals, to close off rivers, are taken without any consultation with the people who rely on those waters for their livelihoods. And that's a big issue if you look at the volume of, the value of inland fisheries around the world and its contribution to hunger alleviation and protein consumption levels. Moving on, assumed and impossible tenure. So the picture on the left is the government water tower. It's from somewhere in India. What we found in the case study in Spain was very interesting. Even in Spain, a very rich country, many of the water supply utilities didn't actually have any formal water rights. It was just assumed that because they were somehow public, they had a right to take water, and that right was protected. In fact, it's not the case. In very many developing countries, it's the same. There's no real protection of water resources that may be used to satisfy the needs of large cities. And then finally, in what we call impossible water tenure, lots and lots of water and sanitation committees established all around the world on an informal basis, very simple, but very problematic because it's not always very clear who owns this infrastructure. And because the water and sanitation committees are informal, they have no legal capacity to hold any kind of water right or any kind of water tenure security. So that's the next point, security. Clearly not all water tenure arrangements confer the same degree of security of water tenure. And in a world where there's increasing competition for water resources, this is becoming a key issue. How to distinguish, how to determine water tenure security, not so easy. There's an initial distinction between those water tenure arrangements that are based on formal law and that have the theoretical protection of the legal system, as long as the legal system works and they're properly implemented, and those that are not. But it's not so simple as to say formal is better, informal is no good, because in many parts of the world, the informal arrangements may be stronger, more secure than the formal arrangements simply because the law isn't properly implemented. Duration is another issue. In principle, the longer the better. But then in a world where climate change is a real fact, if we have too long water rights, we'll never be able to reallocate water to more pressing needs. And then coming back to this point I've just made, implementation of formal law, questions of water governance. If the law is not properly implemented, then whatever water rights you have on paper are not going to be very secure, not going to be very strong. Another interesting point is that water tenure arrangements are basically indifferent to the types of water use. One type of water tenure arrangement isn't usually specifically only for one purpose, one type of use. But it is possible to map different types of water tenure arrangement to different types of uses. So in this simple diagram, we've got the list of type of uses across the top, or purposes for use, I should say, and the types of tenure arrangement on the left. And it's very obvious that nobody's going to build a hydropower dam on the basis of customary water tenure rights. But equally, we can see which type of uses are more likely to have which type of water tenure arrangement. And that's important if we go on to the next slide, which is taken from discussion paper number 10. We can actually map out the different types of water tenure relationship with the different types of water use, and we can identify more or less which type of tenure arrangement is stronger and weaker in terms of water tenure security. And this seems to be the real issue, security of tenure. Can you protect your right? What can you do to make sure that you get your water to protect your interests? So what are the benefits of a water tenure approach that we've found so far? Well, first of all, it's interesting because it's holistic. We can go into a country, we can go into an assessment area, and we can say, please, tell us how it really works. Very often we look at the laws, very often reports and policies are based on what the law says, but the law is normative, it says what should happen. People don't always comply with the law. So before we start any kind of reform, it's really essential to know what's really happening on the ground. Another benefit is it's a more sensitive and nuanced approach. It's non-prescriptive. It's not like you're going in and saying, why are you not doing this? Or you should do that. It's much more subtle, it's much more gentle. And interestingly, in the Spanish case study, the researchers found that when they asked the authorities about illegal groundwater use, which is a big problem in Spain, they were able to find the answers when they talked in terms of water tenure. Previously, when they talked about illegal groundwater use, nobody wanted to talk to them because it was kind of embarrassing. It wasn't good. But talking in water tenure, this more neutral approach, they actually found a lot more information that they had been looking for years. It also allows us to look at questions of implementation and enforcement. Very nice to have beautiful laws on paper. To what extent are they implemented? There's a policy coherence question. Land without water is not much use. Water is linked to forests, fisheries. So if we're talking about tenure arrangements for those resources, good idea to think about water. Also, water tenure allows us to take a more multidisciplinary approach. Very often there's a bifurcation between water policy and water law. The lawyers are put over there, they talk legal stuff. The policy people kind of not very involved in the legal stuff because it's boring or they don't like lawyers, I'm not sure which. And we don't have a proper debate. Whereas in land tenure, of course, law is fundamental to questions of land tenure, but so are matters of economics, of gender, of the society we want. The basic questions about our world are discussed in terms of tenure, land tenure, not just land law. So this is very important, and I think it's a good way for us to work more closely together in an interdisciplinary manner. For me, a key issue is that we focus on users. I find IWRM very top-down, planning, state. If we look at water tenure, we can focus on the users, what are their relationships, the bottom-up approach, and meet with IWRM somewhere in the middle where we understand the reality on the ground. Because if you talk about water resources to any farmer, to anybody who depends on water resources, they have one question: can I get my water? Can I secure my interest in water resources? So I think it's good to focus on water users. And of course, it gives us a chance to complete the framework of the voluntary guidelines by perhaps including water resources, perhaps having some kind of separate arrangement. I can't see how many minutes I've got, Paulo. 2 minutes, okay, very quickly. So coming on to the project and other work FAO is doing, I'd like to mention the Know What project, which ends in June 2022, which is looking at 3 separate issues: water accounting, water governance, and a water tenure assessment in 3 countries, Rwanda, Senegal, and Sri Lanka. Very importantly, we link water tenure with water accounting. You can't manage what you don't know. In most countries, we don't know, we don't have the data. And because we don't have the data, we don't really know how much people are using. So one of the aims of the Know What project is to link the water accounting with water tenure on the basis of a water tenure assessment. So very, very briefly, the idea of the water tenure assessment is to prepare a snapshot of water tenure arrangements in a given assessment area, to compare and analyze those arrangements. And the idea is that a water tenure assessment could be self-contained, it could be part of a water accounting exercise, or it could be part of a much broader water governance analysis. But the idea is to have a methodology for water tenure assessment. So far, we have a water tenure assessment guide, which has been developed within FAO, and thanks to the help of very many external advisors who gave us fantastic feedback. Next, we have to put this into practice. As you can see, it's a 6-step approach from preparation, scoping, research, analysis, validation, and reporting. Just very quickly, some of the analytical approaches we want to look at. First of all, we want to try and identify each type of tenure arrangement and prepare a separate fiche, a separate document to describe it. We want to map the tenure arrangements against the uses. We want to analyze the governance of water tenure to see, as far as we can, through a simple traffic light scheme, the extent to which water laws are actually implemented, to see the extent to which formal law confers real security on water rights holders. We want to therefore then analyze the relative security of water tenure based on the governance assessment, again with a simple traffic light approach. We want to look at the relationship between different types of water tenure arrangement and different type of water use in our research areas. And we have a series of assessment questions which are more discursive about fairness and equity. Nearly finished. Other policy level activities I should just quickly mention. FAO held the expert roundtable in December 2019, jointly convened with the Environmental Law Institute. There's a new FAO discussion paper. It's just about to be issued if it hasn't already, which is intended to push the policy debate a little bit further forward. And I should also mention RRI and ELI's study of basically community-based water tenure, which is a very valuable addition to the debate. So in short, this seems like a new topic. Actually, it's an ancient topic. We've always had water tenure. It's always existed. We just didn't call it water tenure. And with FAO, we're trying to explore through the Know What project and through other initiatives whether we can push this forward. And it seems to me this does offer us a real opportunity to compare experiences in different countries, to learn from each other, and using the typology to have a basis to make that comparison. Because if we just talk about water rights, it's as clear as mud. There are so many different types of water rights that if we just talk about water rights, we're probably going to miss something in terms of comparison. So probably I've gone over time, excuse me, and thank you very much for listening.
Thank you, Stephen, and for this excellent presentation. And I need to say that Stephen is the author of the first water tenure definition, official definition from FAO, because this is very important to have you with us today, and thank you. And I need to say that for sure, with this crazy world that we are living now, with climate change, water conflicts will be growing and growing all around the world. How to work with this, it's our challenge. Okay, thank you again. And I hope that you can wait to participate in our roundtable in the end of the session. And now it's my pleasure to introduce Felicia Marcus. And Felicia, thank you for joining us today. And Felicia Marcus is visiting fellow at Stanford University, attorney, consultant, and member of the Water Policy Group. She most recently served as chair of the California State Water Resources Control Board, implementing laws regarding drinking water and water quality and states' water rights, hearing regional board water quality appeals, settling disputes, and providing financial assistance to communities to upgrade water infrastructure. Before her appointment to the Water Board, Marcus served in positions in government, nonprofits, and private sector. Felicia Marcus is also a board member for Water for Food Institute. Today, she will be discussing water rights and competing water uses. Thank you again, Felicia Marcus. The microphone and our attention is yours.
Thank you. I am very honored to join this group. And I loved that first presentation. I think it was spectacular and really interesting in setting a context for how to look at this. I think in some ways, I'm going to be going to the mundane and giving you what may be a cautionary tale about a water rights system, particularly in the Western United States as an example, but particularly focusing on California, which is probably the most complex. It's one of those things where you could do the good, the bad, and the ugly, but I've chosen not to, just to give you a flavor of some of the issues that are out there. It is an arena where we have a lot going on, where while we like to think of ourselves in California as being on the cutting edge internationally, as well as nationally on things like water quality and environmental protection and a whole host of issues in energy and climate, we're not so much when it comes to the water rights arena. And so I'm just going to try and give you a sense as food for thought of a bunch of issues. I have a lot of words on my slides so that you can use the slides later if you care to go back to them. And so I'm going to go rather quickly so that we can get to the discussion and talk about whatever it is that's of most interest to you. As a caveat, as I said, I'm focusing on mostly the Western US and California, and other resources such as the FAO work, and there's a Global Water Partnership paper that Michael Young recently did that talks about the different options and opportunities for water sharing, which is very interesting, and I commend it to you. And I will probably say more than once that I would not necessarily use this as a model. I think there are just things you might be able to take from it, particularly as we try to figure out how in the changing world that Stephen talked about, greater conflicts, greater density of conflicts between ag and urban users, just between ag users amongst themselves, urban users amongst themselves, or both of them with environmental needs, fishing industry needs, etc. There may be just some pearls that are of use to you. So basically, if we look at the West, it's basically Western water rights deal with the arid West. And if you look at the United States, there's sort of half of it is pretty wet, half of it is pretty dry. The part that's dry has very variable hydrology. And so as a result, certain different forms emerge because some years there's more water than anyone could use. A lot of years there's not enough for everybody. So there needed to be a way to assess how do you allocate water, and it was done in a number of ways. So it's really two different sources to make it overly simplistic. There's the notion of a shared resource, we're using correlative right, which applies to overlying groundwater landowners in the absence of another system. It applies to riparian users, meaning the folks who happen to live adjacent to a water body had a right to a reasonable amount to do their farming or whatever. And in times of shortage, they cut back percentage-wise in equal measure. Then we have the appropriative system that Stephen mentioned. For us, more of a 19th century conception where folks needed to figure out how to allocate it. They looked at water not so much as a common shared resource, but as just another material to be extracted for the beneficial use of production. And so they looked to the mining laws. And the mining laws, where folks would stake their claim, you had a system that was first in time, first in right, so to speak, which is actually a pretty harsh system that I don't recommend for any. It's difficult to implement. It basically says that in times of shortage, the most junior member gives up 100% in favor of the next senior as you go all the way up the line. So very harsh implications. And I speak from personal experience, as you have to in a drought. We just went through the worst drought in modern history in California, and we had to take what are known as curtailments, or cutting people off from their water up to a much higher level than we ever had. And it's very hard to say you get nothing. And I'll talk about some exceptions to that. Just to say these water rights are applied, even though it's generally the same concept, it varies widely or wildly between the Western states. Most of the Western states, if not all, have discarded riparian rights in favor of just having an appropriative rights system. Some apply surface water and groundwater principles in an integrated way. Some do them separately, but similarly. Some do them completely differently. All of them have some kind of surface water regulatory architecture. And then groundwater is frequently implemented through having to go to the courts or or some other body to settle disputes, where you end up with that cone of depression that Stephen's slide showed, where one person puts in a deeper pump and is seen to be interfering with another neighboring landowner's rights. A very expensive system. Adjudications can take 20 or 30 years and cost millions of dollars. And so they're frequently not done except in the urban ag interface or in dense urban areas. And so it really varies across the West. California, without giving you, we are the most complex and the least settled. We still have riparian system. Generally, the riparians are considered to be the most senior, but not always. The appropriative system, as I said, applies these harsh seniority principles. But in the most senior water rights, they were basically claimed by tacking a note on a tree and filing it with the county clerk. And it wasn't until relatively recently that they had to do much more than that. And our senior water rights, which are our pre-1914 water rights, comprise about half of the water extraction in the state. So it's a significant amount of the state of California that has a fairly loosely regulated, and I use the term loosely, it is now settled law that it can be regulated, but in a much less stringent way than the junior water rights. In 1914, the modern system came in where post-1914 claims do need to get a permit, but only a fraction of them have trued that up to a license where they can prove they've been using the water. Because of this beneficial use principle, if you haven't used your water in 5 years, it can be forfeited for reallocation to someone else. That's generally not done, but it is the way the law works, and conflicts are handled in court, or people can go to the state water board. And in that instance, the state water board members acted as water rights judge. So my peers in other states were water rights judge. I was one of the water rights judges, but we also handled the water quality, drinking water, and other programs, and that's by design. I'll talk about that in a minute. Groundwater, an interesting issue, historically just left to the courts. In fact, the water board was explicitly left out of it from a quantity perspective. Quality, not so much. Quality we could engage, and some of our other tools I'll talk about were things that we could apply. But generally, it was the Wild West, as we would say, left on their own. But what started happening was this issue of a cone of depression, people coming in with deeper pumps. You see from space the overdraft, which is a rather dramatic picture during our drought. I would say without those groundwater basins in our Central Valley, the drought would have been far worse for all of us. But the problem is that those basins are being overdrafted at about a 2 million acre feet per year basis. Even outside of the drought, it was much greater during the drought. And you were seeing this tension of folks' wells running dry and not being able to afford to go to court. So to make a long story short, something I spoke about in another webinar, we came through with this breakthrough Sustainable Groundwater Management Act, which is really interesting. And we can go back to in the discussion if you're interested, which is our attempt to come up with something that's more of a collective implementation and not a prescriptive top-down regulation, not following any of the other analogous laws we had, but just to say, look, your sub-basin of a groundwater basin is a collective resource, needs to be managed. It's been hard for you to manage. You can figure out how you're going to share the water however you want, but you've got to have a plan by a certain date. Organize yourselves, have a plan by a certain date, and show how you're going to achieve sustainability in 20 years. And so right now we're in a time of tremendous experimentation. We're looking at what we're doing around the world has a lot of validity. And I just, people are doing trading, they're doing allocations, they're doing fees. It's just a space to be watching right now. Again, across the states, the implementation varies, and this gets to that information, measurement, accountability issue that's Stefan talked about, which is some of the states have fully adjudicated all or part of their state so that everybody knows how much they have, where the water's from, where it's going to go, and they can manage the system. Some have not. For us, only a fraction of our waters have been fully adjudicated. So there's a lot that's faith-based about what people think their water rights are. In a conflict, they come to this. In an emergency like the drought, we can do regulations, but in practice, it is very hard to implement. I have a picture of a famous baseball player in the US, Yogi Berra, who was famous for saying, in theory, there's no difference between theory and practice. In practice, there is, which very much follows on what Sim was saying earlier. We made some changes during the drought, obviously SGMA that I talked about, but also a lot of legislation to help speed adjudications, make them move faster. We also finally got reporting and record keeping through a series of pieces of legislation where it was only in 2016 that the Water Board had regulations that required measurement devices and annual reporting and the enforcement tools to make them happen. So that California very late to this data party, but we really focused on that as the most important breakthrough, because then we would have foundation discussion. There's some ways in which California is progressive in a good way compared to a lot of the other states. We're a unique construct in that we're a 53-year-old combination of the old Water Quality Board and the Water Rights Board, because we do have certain tools that deal with integrating and balancing the natural world in particular, but even as between water users that takes subjective judgment. And so it's a full-time board that brings that human quality. We all have different, I was the attorney member, there were engineers, there are water quality experts at water rights. I was a water rights expert on the board. And we do have these provisions we can go back to, but that I commend you to look at. One is the public trust doctrine, which goes back to Byzantine times and even really has antecedents before that, that overlaying whatever we have, there is a public trust in the natural world, in navigation, in certain issues. And so the courts have been able to implement, and in the state water board can too, saying no matter what your water rights system, no matter what you have on paper, the collective ownership of this resource is a public trust obligation of the sovereign, meaning the state, that time after time the courts have said that we need to implement. It ends up manifesting frequently in fights between the ecosystem and environmental needs and traditional water rights, but it is a very strong doctrine, difficult to implement in our system, but a very powerful one. We also have a really interesting provision in our state constitution against waste and unreasonable use. They use different language, but it's referred to as the waste and unreasonable use provision, which says no matter how senior your water right, you can't use it wastefully. And it is a societal judgment at the time. So for example, flood irrigation in the desert was something that the water board brought a waste and unreasonable use case in. There have been, I was going to talk about this later, but I'll mention it now. We used it during the drought to say it was waste and unreasonable use for the water holders along a water course, no matter how senior they were, to all withdraw their water at the same time so much that fish couldn't even get belly bump to hop to refugia. So that was wasteful from a societal standpoint. Someday off into the future, I think you'll see decisions on waste and unreasonable use that's to recycle coastal wastewater discharge. So it will vary over time, very powerful. And then we have state law that backs us up on that. And then we also have provisions in 2012, we were the first state in the US to pass the human right to water policy, which followed on a UN rapporteur visit calling out how we did such a bad job of getting drinking water to disadvantaged communities, particularly in the Central Valley. And a lot of things have happened since then to try and implement that. And let me give you just a couple examples. I talked about some of the collective issues where we said it was wrong to withdraw so much that the fish got no flow. We had a historic voluntary agreement on the part of very senior Delta riparian water holders who voluntarily gave up their 25% of their water at the beginning of the season so that we wouldn't curtail them if water ran out at the end. And they did it not because they had to, but because they didn't want to be seen as greedy during the worst drought in modern history. But they also wanted to know that whatever they planted, they could see through to the end of the season and not have that harsh water rights hammer come down. We did a number of other things in cannabis we don't have time to talk about, but a lot of things that we worked on to try and implement these different doctrines. And in particular, when the seniority system would have meant we would have cut off all water for small communities for use, municipal systems, we came up with a workaround because water users didn't want us to make a judgment that they had to give up water for the human right to water, we came at it from a drinking water order perspective, and nobody sued us. Again, happy to come back to that. Where we're different in a not good way, obviously, is that we're complicated, we're not trued up, we're not clear, we're not transparent. That transparency issue, I think, is very important in society for a sense of fairness. The overlapping, everything is separately. We have differences of when we can apply the public trust doctrine, when we can't. And I always contrast it with Nebraska. And if I have these stories straight from my Nebraska friends, where you got a state engineer who has the authority and responsibility to implement and could turn off a pump if somebody's lock up a pump, if somebody's violating the rules. I dream of that kind of authority. We don't quite have that. And another place to look is some of, not the Australian reforms necessarily in the 90s, where they separated land tenure and water tenure for the purpose of water marketing and efficiency, along with a lot of the other interesting things they did. But the reforms they did early in the 20th century, where they decided that the California model was not very neighborly and cutting everybody off, and they just switched to shares, where obviously the senior people got more shares, but they share correlatively in a crisis in only 2 categories, as opposed to ours, where we had to, and sometimes unsuccessfully, decide by the nanosecond or the minute who was more senior to another. So with that, there's a sense of it. I don't want it to seem too dismal or too dry. We do have our great Central Valley that produces, you know, one of the most amazing amounts of fruits and vegetables and nuts that serve the world. And we seem to be managing through it despite our complexity, but we definitely need to reform in order to be able to make our water work for people in urban areas, agricultural areas, and the environment. Thanks.
Thank you, Felicia, for this excellent presentation. It's so nice to have this kind of approach. Now we have the big vision about water tenure concept, the idea about the California issue. And I had been living in California in 2012. And California, it's a very interesting state, because it seems like island of the fantasy. It's Disneyland. We can have the best fruits. You can go to the Napa Valley for the best wines. You can go to the Lake Tahoe. But you cannot feel the problem that now California have with the water quality and the water quantity, because it seems like the population cannot see what is happening there. And it's important to change this and to show more and more for the people how bad is the problem that you have in California with the water quantity and quality. Thank you again.
Thank you.
It's a pleasure. And now it's my pleasure to introduce Professor, not Professor, but he told me that he's not professor, but I know that he is Professor Woldezion Mesghinna. And Professor Wood has over 49 years of experience in different areas of civil engineering and water resources. He has worked in the implementation of water resources projects in Africa, United States, and especially for Native American tribes. Nowadays, he continues to work for the US government in water and irrigation districts as a natural resources expert. Today, Professor Wood will discuss US tribal water rights. Professor, now you have our attention and you have the microphone, please.
I'm really excited, to be here today and present the United States Indian water rights doctrine to such a, global audience. I think I've been very lucky today. Stephen and Felicia discussed a portion of the issues that I was planning to discuss, which is really great. And I will continue with, hold on, go back. Okay. as have been discussed by Felicia and Stephen earlier, there are two major, well, three, as far as I'm concerned, three major water rights doctrine. The first one is the riparian rights, which has been discussed earlier, so I don't have to discuss much. You know, these people receive their water rights if their lands are, you know, abut with water body, stream flow, or pond, or lakes, and what have you. In this situation, all water rights are equal priority date. The second is, of course, the prior appropriation, and this has been discussed quite extensively by Felicia. This doctrine was first developed in Colorado, and it is primarily used in the semi-arid Western United States, as has been discussed earlier, and provides water for whoever first use water beneficiary, whoever gets permit. In a sense, I think it is called, in short, if you know the six you know, words, first in use, first in right, that's what it is. As Felicia said, in a way, it is very cruel water rights doctrine, but it is the best available so far, I think, from what I can see. The third, which is very important, yes, in the United States water rights is the reserved Indian water rights doctrine. The reserved Indian water rights doctrine is a bit different from the other rights because it is not a right for individual people. It is for a reservation. It is for a sovereign entity, like, you know, tribal water rights in different areas of the country. So how does this water rights come about? You know, when the United States signed treaties with the tribes some long time ago, in Congress implicitly reserved necessary water right for permanent homeland for the tribes. They said that, as you know, Felicia pointed out earlier, in the West, land without water is almost useless. So what they thought is, Congress thought that the tribes at that time, they were, you know, gatherers and hunters, and the government wanted them to become, you know, to stay in one area and become farmers. And in order to have farming in the United States, you have to irrigate your land. So it was implicit in the agreement between the tribe and the US government that water should be reserved for the tribes. So in 1880s, some non-Indian water users in the Milk River Basin, which is a tributary of the Missouri River in Montana, diverted water upstream of the Indian Reservation, which is the Fort Belknap Indian Reservation. And they caused serious damage to Indian water rights and, Indian water use, their crops and so on. And because of that, you know, they went to court, one after the other. You know, they went all the way to the US Supreme Court. And the US Supreme Court said, yes, indeed, the tribes have reserved water rights. So at that time, the tribes were using about 125 CFS of water in Milk River. And the court gave them all that 125 CFS as the most senior water right. Let me tell you why. What makes the Indian water rights, the reserved Indian water rights, very powerful is that the priority date is the day of the reservation establishment. So the Fort Belknap was established in 1950. And, you know, many tribes that have been established in the Western United States have even been, established before the states were established. So what this tells you is that these tribes have a senior, you know, water rights. So like Felicia discussed, you know, we have been working in many places in California. tribes are usually the most senior water rights. So to go back to this Fort Belknap Indian Reservation, when they got this 125 CFS, but at that time, the court just gave them that water for the amount of water that they were using at that time. So how do you quantify Indian water rights? That was quantified, I mean, the court did at that time is to provide them what they were using at that time. But there was a very important other case, which is, I'm sure Felicia knows very well, the Arizona versus California case, which is the adjudication of one of the most important river basins in the world, which is the Colorado River Basin, which has 7 states, passes through 7 states, and then, of course, the Republic of Mexico. And in that river basin, there are 29 Indian reservations. And when they were adjudicating that river basin in the 1950s, you know, the seniority of the tribes, senior water rights of the tribes came up. So what they did at that time is they said that, oh, the 29, you know, tribes are too many, so let's just concentrate with the 5 tribes that are on the main stem of Colorado River on the lower basin. So they did the study, they did the water right determination, and the water right determination was based on what is called, I'm sure some of you have heard this, and that's the yardstick of measuring Indian water rights. It's called PIA, practicably irrigable acreage. So when you go to court, you have to prove that lands have a PIA. PIA means lands that can sustain long-term irrigation, such that investing in those lands is profitable. In other words, the benefits are higher than the costs. So tribes have to show that they can benefit more of what they are planning to irrigate than their costs. Now, the other important thing about tribal water rights is, extremely important, is that tribes can claim water for agricultural use and non-agricultural use. That's one thing. Tribes can claim water for presently and historically irrigated lands and future lands. So this is what makes it very complex, and you know, not only very complex to quantify it, but also even to regulate it, as you know, we have been talking. I mean, I've been talking today about the regulation of water. So there is the present use, future use for irrigated agriculture, and there is present use and future use for non-agricultural water use, so they can claim all this water. But as you know, the primary water use in the Western United States, say for example, if you go to California, 85% of the water is used for irrigation. You know, there are huge, you know, irrigated lands there, and you know, very high value crops, as Felicia discussed earlier. So in the Arizona versus California, those 5 tribes got about 1 million acre feet of water, about, you know, out of, at that time, you know, the entire Colorado River was estimated to have a natural flow of $15 million, but that was not right. Quite recently, it is in the neighborhood of 14 million acre feet. So there are other tribes after the Arizona versus California who got more water rights. So at this time, Indian tribes own 25% of the total flow of the river of the Colorado River. So it's a huge amount of water that tribes have. And this yardstick is the most important for them, that I'm going to discuss as much as possible today, as much as I have time, which is the PIA. The PIA is the yardstick. I think this is something that everybody needs to understand, that Indian water rights yardstick is primarily irrigated agriculture, although they can make claims for non-agricultural water use, such as DCMI, domestic, commercial, municipal, industrial, in-stream flow water use or religious water use, and so on. The primary water use for the tribes is really quantified using the PIA determination. Once the PIA determination, using PIA determination is quantified, that water can be used for other uses. It doesn't mean that the tribes have to irrigate, their lands. That is a quantification method. That's the way how we quantify Indian water rights. So one Indian tribes in the Arizona versus California, which is the Colorado River Indian tribes, that using the PIA determination, they have now a right of 720,000 acre feet of water. So it's if you can prove PIA, the water supply that Indians get is really, really very high. And the second water right, huge water right that went to court was in the Wind River case, which is in Wyoming. And in fact, I was the primary expert witness there. And in that reservation, the tribes got 500,000, 500,000 acre feet of water out of the Wind River. This is for everything, but primarily that was, irrigated agriculture. And the reason why there was another case is because the states thought that they can win in Wyoming and Colorado and other places where, the growing season is shorter than California. In California, you have, 12 months of the year of growing season. And, the return is very high, the return from crops, because you have 2-3 crops per year. You have about 10 cuttings of alfalfa. While in places like Colorado, Wyoming, Montana, and so on, you only have 5 months of growing season. And the states thought that, the Western states thought that they can win because the Indian water rights takes a lot of water from the states. So they tried their best, but they didn't win. We won. The tribes won. And I can tell you, if we have time, how that thing has happened, because it's a bit different. It's PIA, but I modified the PIA in Wyoming.
Well,
So
2 minutes.
2 minutes?
Yeah, sorry about that.
Oh my God. So the PIA determination, as I said, is the benefits has to be higher. So you need to study water resources, both groundwater and surface water. And you need to determine the natural flow of the river or the virgin flow of the river, because tribes were there first. So they claim water natural flow or virgin flow. So you need to convert historic gauge flows into natural flow. The second thing is you need to conduct land classification, detailed land classification. And third is you need to study the climate in order to determine crop water requirements and adaptability of crops. Then you bring all these resources to the engineer. The engineer then comes up with a project, an irrigation project, a huge irrigation or small irrigation project, which has all, the diversions, the canals, the pipes, the drainage systems, the on-farm systems, and so on. And then the engineer determines the costs at a feasibility level, That's very important. And then the economists determine the net, the net returns of the crops that you grow from there. So if the net returns are higher than the overall cost of the investment and operation and maintenance cost of the irrigation project, then those lands become PIA. If, say, for example, let's take, for example, the Colorado River Basin, the water duty is around 6.17 acre feet. So if you have 100,000 acres that you have shown to become PIA, you multiply that 100,000 acres by the water duty, which is let's say 6 acre feet per acre, which means 600,000 acre feet of water water rights, water rights that the tribes can claim. And then you determine water claims for non-Indian water uses, as I said earlier, for TCMI, and non-consumptive uses like, in-stream flow and so on. I'm sorry, you can't really discuss this within 20 minutes. It's a very, very complex issue, but hopefully during the questions and answers, we'll answer some.
Oh, thank you, Wood. It
Okay.
was so nice to have sharing your experience, this rich experience with us. This is so important for us. And you know that because this, I am in love with the water tenure concept.
Yes.
At the law school, I just learned about the water rights traditional concept. And many times we don't consider other values like religious values,
Yeah.
Cultural values, and things like that, that is essential for the population that is living and using the water.
Yeah.
Because this, I think that we need to change our minds and take another step for the water tenure.
Yeah.
And now we have some time for questions. We have some previous questions that the people sent before the webinar, and I will share with you guys. And we just have 3 minutes to answer these questions. And I will read the first one. And the first one is for Felicia, please, Felicia. And the question is, how do you look upon the intersection of water rights and the human right to water?
Well, you know, I think it's the two have to go hand in hand. How we implement it in California is going to be interesting. I mean, we were ready and poised during the drought when a community in Northern California was going to be cut off entirely from water under the way our rules work because of the human right to water policy of the state. We were going to use our waste and unreasonable use provision. So we have some tools that we can bootstrap to say, we're not going to cut you off 100%. We're going to cut off your ability to water your lawns so they're green in the middle of the worst drought in modern history. But we're going to make sure you at least have a certain amount per capita for indoor sanitation, water use, et cetera, which in California, our public health guidance at the moment is 55 gallons per capita per day, which is very ample, actually, and far greater than more modern water fixtures and water use. So it gives people a bit of a cushion. And the senior water rights holders who hate any decision that chips away at any notion of the sanctity of that right begged us not to do it. And they said voluntarily they would make sure folks had enough water, but we didn't feel that that was a strong enough tool to be able to make good on the human right to water. Just trust us, even though they're nice guys. What did not seem like the right public policy arena. Fortunately, our drinking water division saved us. And this is where it was helpful that they had moved the drinking water division over to the state board in 2014 as well. And they said, look, this is interesting. This is where our rules collide, because we would be issuing under the public health rules a must serve letter. So we backed off on the curtailment, but we issued a must serve letter. And that's how we avoided having to go the legal route, where we were in some ways daring the senior water rights holders to say we couldn't. But we weren't doing it to prove a point. Once we were able to get the water to people, we would. We're implementing the human right to water most aggressively in another arena, which is where we're affirmatively trying to get water to disadvantaged communities, but that's a longer story. And in that case, we have worked, I think, fairly aggressively but deftly with the water user community to say, we need to get drinking water to people. We have a common goal here. Help us get there, or we're going to use all of our tools, mostly in the water quality arena, but also the water rights arena, to make it happen. And there's actually a fabulous coalition between many in agriculture and the disadvantaged community advocacy world. But these kinds of conflicts under climate change will become greater as our level of drought becomes more frequent and greater. So we do need to figure it out in a more formal way.
Thank you. The next question is Stephen, what is a water right? What is a water tenure? Are customer water rights to access water freely? It's for you, Steve.
Yeah, so I mean, so water tenure tries to understand that there are many different types of relationship that people have with water. And many of those relationships are described in terms of water rights. Even in our typology, we talk about customary water rights, formal water rights, and so on and so forth. But the key point we're trying to make is that there's such a variety in terms of different types of water right. A right that you hold in common with other people in a water use organization is quite different to a right that you hold simply because your land is next to a river. A right based on a contract at the national level is quite different to a contract that's protected under international law. So really by not using the word rights, we're trying to say it's bigger than that. And there are many relationships which are not described in terms of rights. They're also part of water tenure. For example, relationships under religious law, maybe not expressed in terms of rights, but they're often just as important as those which are. So that's really the fundamental difference between water tenure, which is a way of looking at all of these relationships to understanding the picture on the ground, and water rights, which are different types of tenure relationships. Have I answered the question?
And Stephen, the person asked if the customer water rights is to access water freely. It's important to say that no, it's not.
No, it's not. It depends on the particular. Yeah, sorry, I missed that. The point is, it depends on the rules of the community that set those customary water rights. It may be free, it may not be. It depends.
Mm-hmm. Okay, thank you. And the next question, Professor Wood, what should be done in order to ensure sustainable water supply for irrigation, according to your experience, Professor Wood?
Thank you. Sustainable water supply for irrigation. Well, first of all, irrigation is used in areas where you have arid or semi-arid climate. So what you have in here is the water flow is not uniform, and it's not enough. And secondly, the other problem is the demand of water by crops is high in these areas because the temperature is high and the growing season is long. So what it means is that you need the demand of water from the water supply is high. So what do we do? I think this is an important question. There are many things that can be done. One is, I think, in fact, if we add more to it, the issue of climate change, where, for example, in Colorado River, due to climate change, according to our analysis at NRCE, we see that just naturally, not because of demand of water, the river is decreasing by 30,000 acre feet every year. So because flows are going to decrease in some areas, in the future, to make it more sustainable, we need to have a very efficient irrigation system, not only the conveyance and distribution systems, but also on farm at the farm level. These are, so we need to use high efficiency irrigation systems. Secondly, there needs to be really good management, really good management, where you need to apply water at a time when the crop needs it. You should not apply water just unnecessarily because you have a water right and you use that water from, say, today at 8 a.m. to 6 p.m., if that's the amount of time given to the water user. So people have to really, we need to teach and train people, to irrigators, that is water users. We need to train them that the amount of water we have is very, very limited and people have to be careful. So management good irrigation system are, I think, the most important thing in order to have sustainable. And then the other thing is, by the way, types of crops that you grow there. There are crops that require less water compared to others. So we need to be, we need to change our cropping pattern from the cropping pattern that we are used to be. We are not in a normal situation at this time. We used to call normal what we used to have, but because of the high population, there is more demand for water, there is more demand for food, and there is more demand for water itself, and we can't survive without it. Food is made out of water primarily. So we need to really understand that we have a very finite amount of resource and we need to use it efficiently.
Thank you, Professor Wood. And the next question, I want to hear all of you, please. Could be very interesting if you can discuss something about what will the future look like as water scarcity becomes more complex, especially across borders. Could you start, Felicia?
Well, sure. I think what starts happening as it becomes more complex is that political pressure gets brought to bear, at least in the US, in the interstate context, as well as the international. I know more about disputes at the US-Mexico border than the Canadian border, maybe because there's more water up there, but doesn't mean there aren't conflicts. We end up having compacts that tend to be agreements between the states with the federal government playing a certain role as being what we refer to as sort of the 800-pound gorilla, or the heavy, saying, unless you guys figure it out, we're going to figure it out, or it goes to court, as in some of the interstate disputes that go all the way up to the Supreme Court. And frequently they appoint a special master to help oversee, to make a decision, but it tends to lead to an agreement because it tends to be in everybody's interest to come to agreement, not right away, because everybody doesn't want to give their water away, but eventually in the way these negotiations go. So for example, the Colorado, which has 7 states along it, just went through a pretty scary and a big set of negotiations to come up with interim drought guidelines and a revised way of looking at it, because under the law of the river, where Arizona is the most junior, they just get hammered. I mean, so like Arizona will kind of cease to exist if you just apply seniority rules. It's a little more complicated than that. And so they do some very intense negotiations, and happily they reached some agreements. The Klamath River up in the north, there were disputes where the tribes won some very important cases in terms of their seniority, which has given them a much greater seat at the table on everything, including Klamath Dam removal, which is one of the most exciting things happening in the US right now as a potentially good news story. So, but there is this framework where the federal government steps in. It's sort of the analog to what we borrowed to do our Groundwater Management Act, where we're going to let people try and figure it out themselves. And if they don't, we step in and do it for them. And nobody wants the state or federal government to tell them what to do. So it ends up being either a forcing mechanism or gives thoughtful people the political cover they need to be able to give away water, because otherwise you become a pariah in your own community. So you as a friend of mine used to say, they can lose it, but they can't give it away.
Perfect. Good.
Yeah,
That's that human dynamic we were talking about.
I think Felicia said it all. There are these compacts between various states in the United States, and there is even, a compact between the United States and Mexico and Colorado River. And there are various, compacts between Canada and the United States, at least the ones that I have worked on, like Poplar River and Milk River and others and so on. But I think we need to look at it more holistically. And what I mean by that is we are using, human beings, have exceeded the amount of water that human being is using at this time than the water that is available. We're talking about quantity of water, but I think Felicia discussed that earlier. There is the quality of water that is a problem, because once you have irrigated lands, and the return flows it goes to the junior water user, and the junior water user, once he uses or she uses that water, it goes to the next junior water user. So what happens to this water is that its quality is deteriorating. By the time it goes, to the end user, it is unusable. So it doesn't mean that irrigation is the best way of, producing crops, but that's what we know so far. So I think we need to work extremely hard. First of all, people have to live with less water. I mean, when we design, housing and other things and water use and so on, if we use 220 gallons per capita per day in Arizona, where not much water is produced in Arizona, the water that Arizona uses comes primarily from Colorado and Wyoming, which is the Colorado River, because they have a 2.8 million acre feet share there. So we need to learn on how to economize or on how to use less. We need to be efficient, not only in irrigation, but also in our homes. When we flush toilets, when we take showers, when we have this, when we have gardens, when we have, all kinds of things. I think we need to be aware that, that water is not there anymore. Look, the fight that is going on between Ethiopia, Egypt, and Sudan right now. I mean, the United States is involved, other countries are involved, the UN is involved. We can't go on like this. So we need to use less water as much as we can. We need to learn. This is a new thing that we need to learn.
Stefan, 1 minute for your vision about this subject, please.
Yeah, so just want to be very clear on one thing, which is that water tenure doesn't really have anything directly to do with transboundary disputes. It's like, just as each country has its own land tenure regimes, they can have quite different land tenure regimes, even if they're situated next to each other. That doesn't impact on one on the other. However, a boundary dispute would impact one on the other. So if one country is claiming the other country's land, it's a bit like one country is claiming the other country's water. So just to be clear, they're separate, and I want to emphasize that because it is an issue that comes up. Otherwise, it's very worrying. What can we do? We need increased international cooperation. We need much more awareness. We need much more training. The problem is for many developing countries, there's very little of the necessary skill base. There are not enough international lawyers. There are a few people who understand international water law. And that's why many of the big cases are determined by lawyers from London, New York, Paris, Brussels, and it's not very healthy. So we need much more training and support and capacity building, and we need to work as an international community through international organizations like FAO and the World Bank to work on these projects. And also not to be naive. You have to be careful, because although we talk about cooperation, countries are in competition with each other on many ways, and one of them is water. So we have to be very, very clear-headed about this kind of project, kind of activity. We need it, but we need to be clear-headed about some of the underlying motives that can arise, even on data sharing. But I've probably gone over my minute there, so I'll stop.
That's very good.
Okay, thank you. This is a so excited issue. It's a so important one, but unfortunately we don't have time for more discussion. And I have a British director that must be on time, right, Christopher? But I need to say thank you, first of all, to our speakers. And I want to say a special thank you for Molly and Francis that are organizing everything in the back, and for Water for Food, and for our directors, Christopher, Neil, and Peter. Thank you. And you have the word, the final word, Christopher.
Sure. Thank you, Paulo. Thank you, everyone, for great presentations and discussions. Very appropriate for the 10th year anniversary of the Water for Food Institute, which is this year, where our mission is essentially water and food security and growing more food with less water. And this is a problem that we're all tackling. And this discussion on water tenure and water rights is very pertinent. So thank you all for attending and hope to see you soon personally.